Well, greetings. My name is William Morris. I am a patent attorney. I've been practicing for, over 15 years now. And what I want to talk about today is mistakes that people make when responding to office actions. And I'm going to go through three of these. The first two are mistakes that I've seen people make when I've been training them how to respond. And the last one is going to be one that I personally made when I was first learning and that I was taught basically how not to make that mistake myself. So let's start. Mistake number 3 is trusting the patent examiner. And this one isn't so much a mistake about you shouldn't work with your examiner, you shouldn't be collaborative. Actually, I think you really should, because ultimately you need to reach an agreement with that patent examiner. And if you go in with a mindset of conflict and I'm going to beat this person and I'm going to destroy this person's an idiot and they have nothing to say, it's going to be really hard to get to an agreement with them. So it's not about, you should be very aggressive or very confrontational with the examiner. It's more about recognizing that you and the examiner are different people. And when you go and you have a patent application, you wrote it, it's got claims that you thought were reasonable. It should be supported. When you wrote it, you thought everything had support. The examiner is a different person. They're reading it with different eyes. They spend a different amount of time with it, probably less time than you did writing it. They have less of an understanding of the invention. And so they very well may get stuff wrong. I remember, as I said, this was something I'd seen in an associate that I was training. And so in this case, the examiner said, this term in your claims, I'm going to interpret it this way. And because of that interpretation, it was treated as covering things, basically transitory media, which are not subject, patent eligible subject matter. And so they rejected it under Section 101. And as it happened, I had written this case. I knew about that issue. And I had an explicit definition of the term the examiner was interpreting. And my explicit definition made very clear that it was not a transmission medium. And the examiner just hadn't seen it. They had overlooked it, they hadn't understood it, whatever the reason. But the associate kind of took the examiner's word for it because it was a very common thing. Some people did make that mistake. And the associate said, look, we need to make this amendment. This is, kind of an issue. And we didn't need to make that amendment. We didn't need to make any amendment, which in general is good. If you can respond to a rejection without amending your claims, that means you're not giving up scope, which is nice. You're not potentially causing a change in the ground of rejection, which is also nice. And so because I knew this case, I said, no, you shouldn't trust what this person says. You should do your own analysis. And in this case, the analysis was, we don't need that change. And in general, I think that's true. The examiner may be wrong, because when you wrote this case, you didn't write it thinking, it's not eligible, or I'm going to write claims that are not supported. I mean, you wrote claims that you thought were eligible, were supported, they were innovative. And if the examiner says that they disagree, which if you get a rejection, then they do say that, there's some kind of a disagreement already. It doesn't make sense, even if you're being very collaborative, which you should be, it doesn't make sense to just trust a person who says that you're wrong. You should say, wait a minute, I'm not crazy. Why are we coming to different conclusions? And the answer might be because they've made a mistake, and you shouldn't necessarily trust someone in that situation. So issue number 3, mistake number 3 is trusting the examiner when writing a response. So number 2, and again, this is something I've seen in practice when I've been training people, is focusing just on the independent claims, not looking at the dependent claims. And again, this is something, it seems rational, right? Because when you have a patent application, in order to get a patent, you have to reach an agreement on at least one independent claim, right? All the independent claims that are going to be allowed, right? Because otherwise they have to be canceled. So it makes sense to look at those. Those are also probably the most commercially valuable. That's why they're the independent. They're certainly going to be the broadest, again, why they're independent. So, okay, focusing on those makes sense. But the dependent claims are there for a reason too. Just trying to say, okay, I'm going to make a little change to the independent claims so that I basically get what I was asking for before. Maybe I clarify it. The dependent claims, you wrote those. I mean, those are all basically built-in fallbacks, right? You thought this is something that's good. There's some reason you put it in there. And if you can say, hey, examiner, you made a mistake on this dependent claim, get that rejection withdrawn, maybe by putting the limitations of the dependent claim into the independent, just get that withdrawn, then they either have to allow it at that point, or you get another non-final action, because if all you do is put the limitations from the dependent claim into the independent claim, and then they put in a new rejection, which they'd have to if they don't allow you, and they've withdrawn the old rejections, then you get another non-final office action. And that's really good, because you don't have to do a request for continuing examination, so there's no money that you have to pay for that. You don't have the delay that's associated with that. You don't lose the patent term that's associated with that. It's good all around. And you don't get that if you just focus on the independent claims and say, okay, I'm going to tweak this, still trying to go for basically the same thing as I had before, maybe just with a little clarification. Because as soon as you make that change, then a new ground of rejection, first of all, you might not get anything at all. But in any case, though, a new ground of rejection that comes based on your change, they can make that final. Then you have to do an RCE. You do an RCE, you pay money, you get delayed, you lose patent term. All in all, sometimes that's the right thing to do. Sometimes you have to do that. But in general, if you can avoid it, generally, I think it's better to do that. And dependent claims are a good way to avoid that from happening. And so the second mistake that I would say that I've seen and that I think it's worth trying to avoid making is to just focus on the independent claims. I think you really should also focus on dependent claims as well. So mistake number one, and this is one I did when I was being trained. It didn't go out into a office action response. Of course, I was being trained. The people who were training me caught this and removed it, as they should, right? That's what their role in the process was. But it's just approaching things too much like a lawyer. And this is something I think this happened, I was very shortly out of law school, right? They teach you all these cases. You learn about claim construction and, prosecution history and disclaimers, and you learn about pleadings and pleading in the alternative. And this may all make sense in litigation, but in patent prosecution, it doesn't really work. So for example, you might have a rejection, and the prior art says, it has features A, B, and C. And, the examiner, they say, we're rejecting you over this prior art because we think element X is taught by this paragraph that has features A, B, and C. Well, you might not know, right? Which of those features is it that the examiner is really relying on? And you could write, as I did, and was caught for it and corrected, a very logically intricate and precise and sophisticated thing, saying, okay, if the examiner is talking about feature A, then that doesn't map to element X for this reason, and B, no, that doesn't map for this reason, and C, that doesn't map for this reason, and if you combine them, it doesn't map for this reason. That does not help you in any case. First of all, it's very confusing. Second of all, so maybe this is sort of a lawyer thing, but you have to write a lot, and some of that stuff is clearly going to be unnecessary, right? So if there's A, B, and C, and the examiner was saying, oh, C is the right one, well, everything you wrote about A and B is irrelevant, unnecessary, and will only potentially be used against you for prosecution history, so that's not good. It just, and I think it just makes a confusing sort of a mess that won't really help you go forward with your case. Another example I'd mentioned, you go through, you're in law school, they teach you about claim construction, right, which makes a lot of sense. But, that doesn't make sense arguing about, this is inconsistent with this in the specification and the examiner has interpreted this wrong. That is going to get you nowhere, because the examiner will say, under the broadest reasonable interpretation rule, I can interpret this not however I want, but I have a great deal of discretion, great deal of leeway, and all of your fancy arguments are going to get you nowhere. And I'll tell you, so if you go into it with that mindset of like, I'm like a lawyer, like I've learned this case law method, we learn all these appellate decisions, and I'm going to apply this like a lawyer, like I was in an infringement suit, it will not help you at all during prosecution. By the way, the better way, when you've got those situations, so for instance, if the examiner says, it's this paragraph, and you're not sure which of those which of the features described in that paragraph the examiner is really relying on, or you think the examiner's misinterpreted or is misconstruing your claims, an amendment deals with both of those problems actually really easily. So what I will do in that case is, in both of those cases, I'll have an interview and I'll say, look, examiner, here's how I understand the prior art, and I'll say, I'll explain what I understand it to say, and I'll say, look, this is my claim, and I'll say, here's what I understand it to say, here's what I was thinking about. How are you rejecting me? These seem pretty different. We'll talk through it. And by the end of that discussion, I didn't have to go through this rabbit hole of A, B, and C and alternatives and interpretations and claim constructions. I didn't have to do any of that. We figure it out, and maybe I make a change, maybe I don't make a change, maybe the examiner says, oh, you're right, maybe we just don't ultimately agree, but now I know clearly what's happening, so I can figure out, oh, do we need to go to an appeal? But it's a lot better than going in trying to apply all that lawyer stuff that you learn in law school, because prosecution is just a different beast. And if you try and come in the way you do, with your case law method and your appellate decisions, you will get things that just do not work, that just don't work. So, all right, so that's the number one mistake. But I think there's another question to think through, right? So these were mistakes I made when I was just starting, or that I've seen people make when they're being trained. But what about in my own practice today, right? Because I'm not perfect. What do I do to avoid mistakes now? And I've got a couple of things that I think are really valuable. I guess the first thing, so more than a couple, the first thing is just interviews. As I said, I think that's an excellent tool to make sure things are on track. If you can get it, if there's time, I think those are almost always good. Another thing that's really good, so I am fortunate enough, I work with colleagues who have been practicing patent law for many years. And if I have a question, if I think, I'm not sure what's the right way to deal with this, I can just talk to them. And I can get the benefit of, experience of people who've been practicing since I was in high school in some cases. And I think that's a really valuable thing to have. Another thing that I think is really useful is just, past cases, right? Because all these file wrappers, you can get these through PAIR. Everything that I do as a patent attorney, especially on issued patents, that is a matter of public record. So there's a huge just wealth of information that you have there. And let me show you how I can use this. So I have this software that I put together. I call it the Arguminer software. And the way this works is I will upload a office action that I have to this software, and the software, what it will do is it will compare that office action to sort of what it's to a database of office actions, and it will go through and it'll see here's all the responses, and here are things that other people have done in similar situations. So let's say, for example, I've got a 101 rejection, and that's I think a really good example, because 101 is such a dynamic area of law. The people, for instance, I'd mentioned, I've got colleagues who have been working in this field since I was in high school. Well, the law is so different, even over the past 5 years, let alone, since I was, before I went to college, that maybe they don't necessarily, that experience may not help as much. So let's just say we've got a 101 rejection, and I'm going to put on a date filter, so in the past couple of years here, because in 2019 there was the patent eligibility guidance came out. Those are the sort of current gold standard for what examiners look at, so I want to make sure it's being applied with that. And let's say I want to make the argument that my invention does not preempt whatever it is they've said the abstract idea is that I'm trying to protect. So I'm going to say I have preempt is what I'm trying to do, and I want the same examiner because I want to see what's happened. And what we can see here is what's happened when people have made that argument. And you can see just very briefly, right? We've got this result list, again, very similar to standard search engine. It says same argument, not claims, not intended to preempt every application, and failure. So I can look at this and say, all right, maybe that's still the right argument, but I need to know it's going to be an uphill battle. And if I've got other things, maybe I can kind of think this through, and I can avoid repeating mistakes that other people have made. And I think that's really useful because there's so much information out there, looking through file wrappers, looking through the public record, and being able to do that is really helpful. And I think it helps me to avoid the mistakes, and also to do the best job that I can for my clients. So there it is, 3 mistakes, ways of addressing them. I hope you found this useful, and good luck and good patenting.